the matter of Union of India through the Assistant Director versus Kanhaiya Prasad, Supreme Court allowed the appeal of Union of India through Enforcement Directorate, which had challenged the legality of the judgment and order dated 6 May 2024 passed by High Court of Patna, whereby High Court had allowed the petition and released the respondent Kanhaiya Prasad on bail. As per the case of appellant ED, some 20 FIRs were registered at various police stations at Patna, Saran, and Bhojpur districts under Section 38, 120B, 378, 379, 406, 409, 411, 420, 467, 468, and 471 of IPC, and under Section 39(3) of the Bihar Mineral Concession Prevention of Illegal Mining, Transportation, and Storage Rules 2019. It was alleged that MS Broadsun Commodities Private Limited and its directors were engaged in illegal mining and selling of sand without using the departmental prepaid transportation e-challan issued by the Mining Authority Bihar, and thus had caused revenue loss of 161,164 rupees to the government exchequer. During the course of investigation of money laundering, search operations were carried out under Section 17 of PMLA at various locations and the premises related with the said company and its directors, including 4 premises of Radha Charan Shah, father of the respondent. During the course of inquiry, statements of the respondent Kanhaiya Prasad, being son of the said Radha Charan Shah, came to be recorded under Section 50 of the PMLA. From the documents seized from the premises of Radha Charan Shah and from the statements recorded under Section 50 of the witness of the respondent and of his father, it was found the respondent accused was actually involved in the process of concealing and possession of the proceeds of crime amounting to 17 crore 26 lakh 85,809, which were used for carrying out the renovation work in the resort at Manali and for the construction work of a school owned by his trust. It was also found that the respondent accused had handled the said proceeds of crime and transferred it by using Hawala networks for acquisition of resort at Manali. It was also alleged that the entire work of the family owned LLPs and of Ma Sharda Devi Buildings and Construction was handled by the respondent to root the proceeds of crime generated by his father to portray it as untainted money. The respondent thus had allegedly layered and laundered the proceeds of crime generated by his father, being a syndicate member involved in illegal sale of sand using Hawala network. The respondent also had allegedly concealed the proceeds of crime by way of purchasing properties, carrying out renovation work and constructions in the family-owned trust property using the said proceeds of crime. Supreme Court held that at the outset it hardly needs to be stated that the objectives of PMLA is to prevent money laundering, which has posed a serious threat not only to the financial systems of the country but also to its integrity and sovereignty. The offense of money laundering is a very serious offense, which is committed by an individual with a deliberate desire and motive to enhance his gains, disregarding the interest of the nation and society as a whole, and such offense by no stretch of imagination can be regarded as an offense of trivial nature. The stringent provisions have been made in the Act to combat this meanness of money laundering. It is well settled position of law that Section 45 of the PMLA, starting with the non-obstante clause, has an overriding effect on general provisions of the Code of Criminal Procedure in case of conflict between them. Section 45 imposes twin conditions for the grant of bail to any person accused of an offence punishable for a term of imprisonment of more than 3 years under Part A of the schedule. The two conditions are that the prosecutor must be given an opportunity to oppose the application for bail, and the court must be satisfied that there are reasonable grounds for believing that the accused person is not guilty of such offence and that he is not liable to commit any offence while on bail. As well settled, these two conditions are mandatory in nature and they need to be complied with before the accused person is released on bail. It is further required to be noted that Section 65 of PMLA requires that the provisions of CRPC shall apply insofar as they are not inconsistent with the provisions of PMLA, and Section 71 provides that the provisions of PMLA shall have overriding effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Hence, the conditions enumerated in Section 45 will have to be complied with even in respect of application for bail made under Section 439 of CRPC. Further, Section 24 provides that in case of a person charged with the offence of money laundering under Section 3, the authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. Therefore, the burden to prove that proceeds of crime are not involved in money laundering would lie on the person charged with the offense. Supreme Court referred to the judgments in case of Gautam Kundu versus Directorate of Enforcement, Rohit Tandon versus Directorate of Enforcement, Tarun Kumar versus Assistant Director, Directorate of Enforcement. In case of Vijay Madan Lal, the provision post the 2018 amendment is in the nature of no bail in relation to the offense of money laundering unless the twin conditions are fulfilled. The twin conditions are that of reasonable grounds for believing that the accused is not guilty of offense of money laundering and that he is not likely to commit any offense while on bail. Considering the purposes and objects of the legislation in form of 2002 Act and background in which it had been enacted, the Bijan Madan Lal case, it was stated that owing to the commitment made to the international bodies and on their recommendations, it is clear that this is a special legislation to deal with the subject of money laundering activities having transnational impact on the financial systems, including sovereignty and integrity of the countries. This is not an ordinary offense. To deal with such serious offenses, stringent measures are provided in the 2002 Act for prevention of money laundering and combating menace of money laundering, including for attachment and confiscation of proceeds of crime, and to prosecute persons involved in the process or activity connected with the proceeds of crime. In view of gravity of the fallout of money laundering activities having transnational impact, special procedural law for prevention and regulation, including to prosecute the person involved, has been enacted, grouping the offenders involved in the process or activity connected with the pursuit of crime as a separate class from ordinary criminals. The offense of money laundering has been regarded as an aggravated form of crime world over. It is therefore a separate class of offense requiring effective and stringent measures to combat the menace of money laundering. There remains no shadow of doubt that the consideration of two conditions mentioned in Section 45 is mandatory, and that while considering the bail application, the said rigors of Section 45 have to be reckoned by the court to uphold the objectives of PMLA. It is no more res integra that the offense of money laundering is an independent offense regarding the process or activity connected with the proceeds of crime which had been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offense. Hence, involvement in any one of such process or activity connected with the pursuit of crimes would constitute offense of money laundering. This offense otherwise has nothing to do with criminal activity relating to a scheduled offense except the proceeds of crime derived or obtained as a result of that crime. Any casual or cursory approach by the courts while considering the bail application of the offender involved in offense of money laundering and granting him bail passed by passing cryptic orders without the considering the seriousness of the crime and without considering the rigorous of the section 45 cannot be vindicated. The respondent shall thus surrender before the special court within 1 week of this judgment.